Hello everyone, I am Sidhant. Today, the fifth chapter of the legal and regulatory aspects of the banking of the JAIIB syllabus is going to be completed. The chapter name is Public Sector Banks and the Cooperative Banks. The public sector banks includes State Bank of India plus the nationalized banks plus regional rural banks. All three comprises of the public sector bank. And the cooperative banks are ruled or governed by the Cooperative Act plus some more acts. If we take the public sector bank, for example, State Bank of India, he has its own act, that is SBI and its subsidiary act of 1955. They have to follow this act plus the Banking Regulation Act of 1949. See, in India, everything comes with an act or law. So when SBI comes, it comes with the SBI Act of 1955. But since it's a bank, they have to follow the regulation. So the provisions of the Banking Regulation Act are also applicable to this special statute of SBI. Similarly, the cooperative banks has to follow his own provision, that is Cooperative Act of 1912 plus Banking Regulation Act plus the State and the Central Act, which is a separate act to run these cooperative banks. The next topic is State Bank and its subsidiary. As we know that the State Bank of India Act 1955 constitutes the State Bank of India as today. Previously, this in simply we can say that it was undertaken by the government. There is one bank called the Imperial Bank, which is the first bank of India, which was undertaken by the government as State Bank of India. So it has in the act of SBI Act of 1955, there are some provisions which they have to follow. For example, it's also mentioned in our course book that the government, the main shareholders is the government, and if there are some shareholders other than the government, then the maximum voting rights can be exercised is 10%. And the State Bank of India central office is in Mumbai and the head office is in Mumbai, Kolkata, Chennai. The board of directors in the State Bank of India is maximum can be rule is 5 years, and anyone can leave by giving 3 months of notice period, which is by and far follows in India in every organization or in every government jobs. The main businesses of this SBI, the main purpose of introducing the SBI is it acts as an agent of RBI. If RBI wants to implement something related to the government, like he wants to issue treasury bond, then he can make the SBI the primary dealers of that bond or anything. So this is act as an agent of the Reserve Bank of India. And one point I want to say in this, though it belongs to the previous chapter, the audit and account of every bank has to make from the 31st of March, that is from 1st April to 31st of March. This time period they have to file the return of this. The next topic is regional rural banks. These are the banks which comes into existence after the passing of Regional Rural Banks Act of 1975. The thing is that why the government need the regional rural banks? As we know that our 60% of the population lives in the rural area, and also they are engaged, around 57 to 60% of the people are engaged in the agriculture activity. So there should be some separate entity which particularly deals with this agricultural part, which are the backbone of our Indian economy. So the regional rural banks comes into existence, and there are in this act there are some provisions which are not mentioned in any other act which they have to follow, plus they also have to follow the Banking Regulation Act and also the others rules and regulations prescribed by the central government or the RBI. The regional rural banks are run by one of the provisions of this act is that the RRB, the composition of 15% of the RRB has to be kept with the state itself, and the remaining 85% of the shares or part can be distributed between the central government or the sponsor bank. What are in sponsor bank? The sponsor bank are nothing, are already existed bank like any of the public sector bank which can sponsor or administer or manage that regional rural banks effectively, because they are the experienced one, and regional rural banks, as it is new, they might not have that experience to run the banking system in India. So the sponsor bank concept comes into picture, and the business is same as that of the general bank. There are no discrimination in that. Though the biggest advantage they are exercising in the regional rural banks, that especially for the employee like us, that they are having a pension system, the main pension system, not the NPS that we are getting. They are having a separate pension system, which was very much there when our father works for the government organization. The next topic is nationalized bank. As we know that the banks are nationalized for the especially for the interest of the public by the Indira Gandhi government in 1970s and 80s. So how this nationalization took place? First of all, there is a provision we have learned in the previous chapter, that there is a provisions of undertaking of the banking businesses by the Indian government. So by exercising that act, the Indian government are able to nationalize the bank. And there also, at that time when the nationalization took place, there is a Banking Companies Acquisition and Undertaking Act of 1970 and 1980 took place, and the undertaking held. And there are also some schemes at that time which passed, like Management and the Miscellaneous Provisions Scheme 1970 and 1980. These schemes and acts are nothing but to exercise the freely flow of the ruling or management of the companies. The management of the nationalized bank are done by the board of directors, as we know that, and that there are some provisions in about the directorships of the banking nationalized bank, like the directors are elected or selected by the central government or elected by the shareholders. There are maximum 4 whole-time directors, others are part-time directors. These 4 whole-time directors are appointed by the central government by the central government on recommendation of the Reserve Bank of India, and that recommendation on the basis of the particular person has supervision or have experience in supervising any banking companies before. The next one of the director represents the workman employee, that is the office, the clerk or assistant, and another one director representing the officers. And one other directors is chartered accountant with a 15 years of experience, and maximum the 6 directors can be appointed by the central government. With that, 4 whole-time directors and 2 might be part-time directors. And there are also provisions of the additional directors by the Reserve Bank of India. As just before, the next topic is applications of the Banking Regulation Act to the public sector bank. As we know that there are many acts which governs the banking system. For example, even the SBI, for the SBI, there is a SBI Act of 1955 plus the Banking Regulation Act, both acts in it. And so for all the public sector banks, which includes SBI as well as the nationalized bank as well as the regional rural banks, there are acts of their own plus the acts of the Banking Regulation Act. The schedules or the part which applies to the public sector bank from the Banking Regulation Act is, though it is not important, but I am mentioning it. The section 10, 13 to 15, 17, 19 to 21A, 23 to 28, 29, 30, 31, 34, 35, 35A, 36, 45Y to 45ZF, 46 to 48, 50, 52 and 53. Only these provisions are applied to the public sector banks. The next topic is disinvestment of the shares by the government. As all these public sector banks, the majority shareholders is Government of India, so he can share his shares to the public or any other institutions as required. If the government needs company, he is able to disinvest his shares from the total shares of the particular banking companies. So the disinvestment can be done by the government, and there are also some rules and the provisions which are passed time to time in order to have a very liquid situation, so that it can be done without any problems. Like the Banking Companies Acquisitions and the Transfer of Undertaking Amendment of 94 and the 95, it's done for the shareholders specifically, which allows dividend to the shareholders. As we know that the one who attains the shareholder or the shares, they have to give the dividends if the company runs in the profit. The next topic is the cooperative bank. As we know that the cooperative bank runs by the Cooperative Societies Act. The Cooperative Society Act of 1912 is of two kinds. One is of particularly belonging to one state, and if the cooperative bank runs in more than one state, then the Multi-State Cooperative Act is applied on it. And again, we have already discussed that the Banking Regulation Act under section 56 applied to this cooperative bank as well, and this section 56 was introduced in the 1965 for the betterment of the working or the service of the cooperative bank in India. And there are cooperative banks, three kind or many kind of the cooperative banks, but generally the state, central and the primary cooperative banks are in importance. There are also some cooperative banks like urban cooperative banks, rural cooperative banks, lots of cooperative banks is there, but the state, central and primary has it's mentioned in the book, so these we will restrict to that. State is used for the financing purposes, and the central cooperative bank is also for the financing others, especially in the district. Cooperative banks has their range to the district, and the state cooperative bank has its range in the states. And there is one primary cooperative banks. This does the banking businesses, but the cooperative society has its members. It works only for its members. The one who is member, they will share the profit, they will share the product, they will share everything. That is the concept of the cooperative. And the paid up capital required for the opening of the cooperative banks is rupees 1 lakh only. And the cooperative society, the cash, as we read in the previous chapter as well, that they have to keep the reserves, cash reserves as prescribed by the Reserve Bank of India. That is 3%. They have to keep with themselves. They do not have to file the returns or have to keep park with the Reserve Bank of India or at all. So they keep their reserves on their own, but they have to comply the other norms and the rules as prescribed by the Reserve Bank of India. For example, the restriction on loans as applied to the main banking system is also applied to it. Like they do not allow to give loans on the shares, they do not allow to give loans to the directors, they do not allow to give loans to the directors whose interest in some companies, etc. And they also have to to get the license from the Reserve Bank of India under Section 22 of the Banking Regulation Act has to comply with the CRR, SLR, liquid asset criteria as given by the Reserve Bank of India. And one special thing, that the account and the audit statement of yearly, which is being sent to the RBI by the other banks, they have to first send it to the NABARD, National Bank for Agriculture and Rural Development, the NABARD full form. And what NABARD do, it keeps the development of the rural area, it keeps check the development of the rural areas. In short, the account and the audit statement has to submit to the NABARD, and then NABARD forward to the Reserve Bank of India. And the provisions of the DICGC, that is Deposit Insurance Credit Guarantee Corporation of the 1961, is applied also to the cooperative banks. What it does, DICGC is an insurance, gives an insurance of the amount of deposit by the particular individual. For say, let's example, you have deposited money in your bank. So the DICGC takes care of the insurance. If someone by fraud or any spy have taken money from your account, as done as the case was in Bangladesh when the amount was removed from the account, then DICGC comes into picture as it gives the insurance. He will repay the amount of what you have lost in that attack. So DICGC is that. Cooperative, the DICG, if they want the DICGC insurance, then they have to register separately for that. And there is one more concept about the cooperative bank, is eligible cooperative bank. It's mentioned under section 2GG. Under these provisions of section 2GG, if the cooperative bank can be called an eligible cooperative bank only if they have a laid down provisions and the rules regarding winding up if something bad happened to the cooperative banks, or regarding the management of the company, whether it is managed by the board of directors or whether it is managed by a single individual or anything. They have well laid out provisions already written. And the liquidation preferences, if they have to wind up, then who will be the first that will get his deposit if something happened to these cooperative banks. That's all. Thank you.